Good afternoon and welcome to the Children and Family Affairs Subcommittee meeting for March the 3rd, 2026. We're going to begin with a prayer by Representative Kiesling, and please, we're going to stand and please remain standing for the pledge.
Let us pray. Lord, we just thank you. We come to you with humbleness. Lord, we just thank you for your grace and your mercy. Lord, we love you. Lord, there's so much to be thankful for. Most of all, we just thank you for giving your son, Lord, to save our souls. Lord, there's much going on in the world. We just pray for our military. We pray for those families whose member gave up over the past 2 or 3 days. Just pray for them. I want you to feel their presence, Lord. It's only you can. We just thank you for each and every one here in attendance, Lord. We just pray for each and every committee member and give us the wisdom today to make the right decisions. These things we ask in thy name. Amen.
Amen. Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Has everyone checked in? Madam Clerk, would you please open the board for the roll? Madam Clerk, what? Madam Clerk, would you please take the roll?
Madam Chair, you have 5 members present. You have a quorum.
Thank you, Madam Clerk. Members, do we have any personal orders? Chairman Doggett, you're recognized.
Thank you, Chair Lady. Members, early this morning, I received a text from a gentleman that used to be our colleague, and he is now a circuit court judge. And the Honorable Bruce Griffey texted me that his daughter Madeline was going to be up here today advocating with her colleagues, the University of Tennessee Medical Program. She is in the audience with us today, along with her friend, David DeBove. If you would stand so we can welcome you. So thank you for being with us today. She's grown up some since she was here.
She certainly has.
Yep.
Looks more like her mama.
Thank goodness.
Are there any other personal orders? Seeing none, we have some quick housekeeping to do before we get to the calendar. Item number 1, House Bill 1904 by Chairman Terry has been rolled 1 week. Item number 7, House Bill 2154. Oh, that's not right. No, item number 5, House Bill 1734 by Chairman Moody has been rolled 1 week. So now we move up to item number 2, House Bill 2276 by Chairman Hicks.
Motion. Second.
And I see that you have an amendment. You have 2. Is there one that you want to go with?
Yes, ma'am. And we will go with the amendment 014001.
Motion. Second.
Properly motioned and second by Chairman Doggett. So would you like to go ahead and put the amendment on? Okay.
Please.
Is that okay with the members? Okay. So we are voting to put amendment 14001 onto House Bill 2270. All those in favor say aye. Aye. Those opposed, no. The ayes have it. You are recognized on House Bill 2270 as amended.
All right. Thank you, Chair Lady. And House Bill 2270 creates the Children's Digital Protection Fund. The CDPF ensures that money recovered from the tech companies that harm minors is reinvested directly into protecting and restoring the mental health and safety of Tennessee children. That's what the bill does. A little context behind why we're filing the bill and why we need it. The Tennessee children are facing unprecedented mental health challenges and safety risks linked to social media, online gaming platforms, and other digital technologies. The Tennessee Attorney General's office is actively investigating and litigating cases against digital companies for harm to minors. In connection with the resolution of those legal claims, the state may receive significant proceeds. So what does this fund do, this Children's Digital Protection Fund? It allows the General Assembly to appropriate funds for the following: mental health services and treatment for minors, suicide prevention initiatives, research on the impact of social media and technology on children's mental health, law enforcement resources to combat digital exploitation of minors, education programs for parents, schools, and communities, and then it provides support for Tennessee's K-12 Mental Health Endowment Fund. And with that, I'll answer any questions that you may have.
Thank you very much for bringing this bill. I think we all know some people that their children have used these to abuse other children or to actually take their own lives, maybe accidentally or take their lives. So
Absolutely.
this means a whole lot. So thank you for bringing this. Are there any other questions? Representative Towns?
Thank you, Madam Chair Lady. As well, thanks for the bill. Got a question as it relates to, well, a couple of things. Is anybody else doing this across the country that we know of?
You're recognized.
Thank you, Madam Chair. I'm not sure.
What I'm trying to get
You're
at
recognized.
is, thank you, ma'am. How much possible revenue do you think we can generate with this kind of action? And will the money go to healthcare concerns, or will it go directly to the child that's been affected? How are we going to deal with that?
A good question. And so as far as the total monetary value of this fund, of course, it's still being litigated.
Okay.
So to give you a number, I would hate to give you a number because I don't know what it's going to be. As far as how it's going to be appropriated, it would go, again, not to be redundant here, but it would go for the mental health services and treatment for minors. There's many programs across the state. That's how they would go into these programs. Many suicide prevention initiatives. And of course, this time of year, we all hear from many of those folks who would actually provide these services. And so that's how most of this would go.
Got it. Madam Chair,
Representative Towns?
will the child that's possibly been affected, or we know they have been negatively affected by it, will they be able to receive those services free?
Yes, through the fund. I think
Good.
that would be the
Good,
intent.
good. I hope so.
This.
Hope so. Madam Chair, thank you.
Any other questions for Chairman Hicks? Seeing none, are we ready to vote? Madam Clerk, would you open the board? If you are in favor of House Bill 2270 moving out to judiciary, vote aye. Those opposed, vote no. Madam Clerk, would you take the vote, please?
Madam Chair, you have 5 ayes and 0 noes.
Thank you, Madam Clerk. House Bill 2270 moves out to, as amended, moves out to judiciary full.
All right, thank you, Madam Chair.
Thank you.
Members.
Thank you for the bill. Next is number 3, House Bill 2429 by Chairman Farmer. Probably motioned in second. Chairman Farmer, you are recognized.
Thank you, Madam Chair. Members, we're on House Bill 2429?
Yes.
Very good. Looks like I have an amendment we need to put on here, if you don't mind. Just kind of cleans up section 1 of the bill. It's drafting code 14353.
Okay. Properly motioned in second. Are we ready to put it on and then let him describe the bill?
Yeah.
All right. All those in favor of House Bill of Amendment 14353 going on to House Bill 2429, say aye. Aye. Those opposed, no. The ayes have it. Chairman Farmer, you're recognized on House Bill 2429 as amended.
Thank you, Madam Chair. Members, section 1 adds a new subsection to clarify that Family Rights and Responsibilities Act does not override the legal authority such as court orders, existing statute, court rules, or case law. Section 2, this is a technical change. TCA 366-404B contains an outdated cross-reference to the child custody best interest factors. So we're just going to clean that up, make it a little tighter. Section 3 creates a new statute, Title 37, to give juvenile courts the discretion to award attorney's fees in child-related disputes. And finally, Section 4 permits courts to temporarily suspend child support obligation and a child support obligation when a dependency and neglect proceeding intervenes. So that's an overview of what the bill does. Be happy to answer any questions you all may have.
Are there any questions for Chairman Farmer? Question, Representative Towns, you're recognized.
Question on the bill.
Question's been called. Are we ready to vote? All those in favor of House Bill 2429 as amended, moving out to judiciary full, say aye, or let's vote on the board. But yes, support, or no, if you're not. Madam Clerk, would you please take the vote?
Madam Chair, you have 6 ayes and 0 noes.
House Bill 2429 as amended moves out to full judiciary. So next we have item number 4, House Bill 1966 by Chairman Farmer.
Second.
Properly motion is second. I see an amendment.
Yeah, it looks, thank you, Madam Chair. I believe that's Amendment 14078.
Would you like to go ahead and put that on the bill?
I
and
would,
then-
it
okay.
reroutes the bill. It makes bill.
Properly motion is second. All those in favor of putting Amendment 14078 onto House Bill 1966, say aye. Those opposed, no. The ayes have it. You're recognized on House Bill 1966 as amended.
Thank you, Madam Chair, members. The purpose of this bill is to establish a statewide quality assurance program within the Department of Children's Services to ensure consistent, high-quality service delivery across Tennessee. We want to build on the consistency that DCS has here, and this would create more of a regional component. Now, I know we've had some discussions, Madam Chair, we've talked about this, that we may need to, whether or not the local folks have the ability and the resources to, handle this, but this is something I'd like to see moving forward if we could, and kind of, we need to work on it, we can.
Absolutely. Any questions for Chairman Farmer? Seeing none, are we ready to vote? Okay, all of those in favor of House Bill 1966 as amended, vote aye. Those opposed, say no. Madam Clerk, would you please take the vote?
Madam Chair, you have 6 ayes and 0 noes.
House Bill 1966 moves out to full judiciary. Thank you.
Thank you, Madam Chair, members.
As amended. Okay, that's rolled. Next, we have number 6, House Bill 1245 by Representative Reedy. Let's move him, without objection, we'll roll him to the Hill. Next, we have number 7, House Bill 2154 by Representative Raper.
Motion. Second.
Your properly motion is second. Representative Raper, you are recognized.
Thank you, Madam Chair and committee. This bill
Oh, wait,
requires.
I do see an amendment. Is that?
Yes, I'm sorry. Would you like the number?
Yes,
ma'am?
please.
Okay, it is 013691.
Motion on the amendment. Second.
Properly motion is second. Would you like to go ahead and put that on now?
Yes, ma'am.
All those in favor of putting Amendment 13691 onto 2154, say aye. Those opposed? The ayes have it. You are recognized on House Bill 2154 as amended.
Thank you, Madam Chair. This bill requires court-appointed guardian ad litem, which I'm going to refer to as GAL from this point, in divorce cases involving minor children to complete appropriate training by a qualified professional. The training has to have these 3 components: early childhood development, child development, adolescent development. GALs make recommendations that directly impact children's lives and custody arrangements. It ensures GALs have a strong understanding of child development, promotes better informed decisions focused on the best interests of the child, provides consistency and professionalism across the state. Also, courts may still appoint someone who hasn't completed the training yet, but they're going to have 3 years from that point. And that will start actually in July 1, 2026, and will conclude in 29, July 1st then. It does not remove GALs. It's a reasonable timeline for training. Courts can implement this within existing resources. This bill ensures that guardian ad litems working in cases involving children are properly trained in child development. When courts are making life-changing decisions about children, we should ensure the professionals involved and understand childhood and adolescent development. Finally, this is a common sense, child-focused measure with no significant fiscal impact. Thank you. Stand for questions.
I have a couple of questions I want to go ahead and ask. Who will train them?
That will be court appointed, but we have worked out through a court improvement programs that hopefully that will be all free to them.
And who will that court be? I mean, who will they be?
Can you?
I mean, are they, I mean, some of these are already attorneys. So what person will train them? Just that, what job will that person have?
Well,
What
they
training?
they are going to be checked, all of them, everyone existing, and see if they are up to this current recommendations for certification and training. If they are not, at that point, they will move from there.
Chairman Doggett, you're recognized.
Thank you, Lady Chair. I know sometimes in court settings that the judge will appoint an attorney as guardian ad litem. Is that going to be, if they are, and I mean, there's 95 different counties across the state and 95 different ways of doing it. If there may be cases where an attorney is just present in the courtroom, kind of like being appointed as being counsel for someone who's indigent, you know, is this going to apply the same way that if you're appointed by the judge as guardian ad litem, are you going to have to be required to do this training and also be able to represent the interest of that child?
If it's temporary, obviously not. But if it's more of a permanent appointment, then yes, you're going to have to in 3 years get that certification, because it's just child first based bill, and we're going to do everything to get those guardian ad litems trained as much as possible.
You're recognized. I'm sorry.
Do we have full-time guardian ad litems across the state?
We do. And that's why judges know where to choose from in certain instances. Some we don't have enough. We're not staffed enough in certain, but yes.
You're recognized.
I know in my district, we've got some attorneys that's what they specialize in. So they also represent a wide variety of cases, but they would know that they also do that. They would want to go and do this training so that when they were appointed in these instances, they would be on par. So I'm picking up what you're putting down now. Thank you.
Yes, sir. Thank you, Madam Chair.
First, I have another question. The first thing, it says qualified professional will do the training. So where will you get these qualified professionals? I guess that was what I was trying to ask a while
Sure.
ago.
And I'm telling you that I don't completely know the answer to that, but I will say that I think there are going to be groups represented that the judges will turn to and say, these are the choices, or this is the group that is chosen that can train you officially. So.
You're recognized.
Thank you, Chair Lady. I think there is some professional development out there for attorneys that it already exists, that they are able to go to specialized training for this type of law already.
Yeah, let's go out of session and see what ad litem, can we do that? Can you tell us what they are and how they're trained, please? We're out of session. You're
Michelle,
recognized.
thank you. Michelle Fogarty, Legal Services. Under the Tennessee Supreme Court rules, a guardian ad litem is a lawyer that's appointed by the court to advocate for the best interest of the child and to ensure that the child's concerns and preferences are effectively advocated in the proceeding. I don't know that we have codified specific training for guardian ad litems. It would just be part of their continuing legal education that they are required to receive 15 hours a year.
Are there any questions for legal? Are they part-time, are they full-time, or are they both?
They are appointed by the court, so it's an appointed case that the guardian ad litem, they're appointed to. So they have other cases that they work. That's not a full-time position. They're just appointed to represent the child in that matter, just as if they are appointed to represent an indigent party in a dependency and neglect or something like that. They're appointed.
Thank you. Representative Bosso, you're recognized.
Thank you.
Oh,
Madam-
is it for legal or for, okay.
It's for legal. Thank you, Madam Chair. Ms. Fogarty, could you address the question that was raised earlier about whether appointment of a guardian ad litem is temporary or permanent? Because in looking at the statute that's involved here, section 36-4-132, it provides that, quote, in an action for dissolution of marriage involving minor children, upon motion of the party, the court may appoint a guardian ad litem for any minor child of the marriage, close quote. And so it appears that the statute contemplates an appointment for however so long the case lasts, not permanently looking over the child the way a guardian or a conservator might. So could you address the question of whether the role of a guardian ad litem is a temporary one or a permanent one?
Michelle Fogarty, Legal Services. In this instance, this is a temporary appointment just for the duration of the matter that's proceeding before the court.
You're recognized. Chairman Johnson. Go back in session. Are there any other questions for legal? Seeing none, we're back in session. Chairman Doggett, you're recognized.
Thank you, Chair Lady. I may be incorrect here, but it looks like there is training right now that guardian ad litems must go through. But I'm denied access on the AOC's website because but there's requirements and resources there. I see him back there.
Representative Raper, would you like to roll this so we can maybe work on it a little bit?
Absolutely.
Okay.
Or you could roll it to
Without-
the hill and let me go ask a couple
Let's
questions.
just roll it a week and let's work on it a little bit.
Sure.
Is that okay? All right.
Absolutely.
So without objection, House Bill 2154 is rolled 1 week.
Thank you.
Without objection, we're going to go out of order again and go back to number 6, House Bill 1245 by Chairman Reedy. Properly motion and second, you are recognized.
Thank you, Madam Chair and committee members. I do have an amendment that makes the bill 13786.
Okay. All those in favor of adopting Amendment 13786 to House Bill 1245, say aye. Those opposed, no. Would you like to go ahead and put that on the bill and then?
Yes,
stop your
ma'am,
bill?
please.
Okay. So all of those, okay. You're recognized on House Bill 1245 as amended.
Thank you, Madam Chair and members. Remember House Bill 40 last year? It ended up, becoming Public Chapter 418, and we had done a TASER study assessing juvenile detention capacity in Tennessee. TASER did an amazing job because they come up with 81 pages. Now to House Bill 1245, through that previous TASER study, we come up with Senator Roberts and I additional questions that may help us in deciding what legislation or what do we need for juveniles in the state of Tennessee. The summary of this bill as amended: the current structure of licensing and oversight mechanisms for residential facilities licensed, approved, operated, or contracted by the Department of Children's Services or a juvenile court for the placement of juvenile detained prior to adjudicating hearings or who have been adjudicated delinquent or unruly and committed to DCS custody. And number 2, the question would be the licensing and oversight models used by other states, the licensing and oversight models used in Tennessee by other state agencies, and opportunities for improvement in licensing and oversight mechanisms for residential facilities, housing, and treating pre- and post-adjudicated juvenile offenders. And that's our intent in asking TASER to review this and see what we need to do further.
I stand for questions.
Are there any questions for Representative Reedy? Seeing none, are we ready to vote? All those in favor of House Bill 1245 as amended, say aye. Those opposed, vote no. Madam Clerk, would you please take the vote?
Madam Chair, you have 6 ayes and 0 noes.
Thank you, Madam Clerk. House Bill 1245 as amended moves out to judiciary full.
Thank you, Madam Chair, members.
Next, we have number 8, House Bill 590 by Representative Ashley. He's rolled to read. House Bill 590 is rolled 1 week. Next, we have number 9, House Bill 1692 by Representative Renaud. Properly motioned and seconded. Representative Renaud wants to roll this 1 week, but she has someone here to speak. So we're going to let them speak today and then roll it 1 week without objection.
Would it be okay if I explain the bill just so you have some background on it before she testifies?
Sure.
Thank you. Thank you, Chair Lady. Under current Tennessee law, there are certain procedural allowances that are allowed in adoption when the child is related to a petitioner. What this amendment does is extend that same recognition to the children who have already lived in a non-related petitioner's home for at least 6 months under a prior court order. So I want to repeat that because this bill only applies when there has already been a judicial order of placement or custodianship with the non-related petitioner. This bill does not it's not automatic. It just gives judges discretion to be able to waive the home study. It doesn't require them to do it. So courts retain the full authority to order the studies or request investigations or deny adoptions if there are any concerns. This bill just trusts judges the same way that we already do whenever how the law does for relatives. So it provides a shortened path to permanency for children who are already thriving in stable court approved homes. Thank you.
Without objection, we're going to go out of session and call Rachel Welty. I'm sorry, Judge Rachel Jackson. We are out of session.
Good afternoon.
Could you please introduce yourself and say who you're with, please?
Yes, my name is Rachel Jackson. I'm going to introduce myself in 2 different ways because I wear 2 different hats. I am Judge Rachel Jackson of the Lauderdale County Juvenile Court. I've been on the bench for roughly 30 years, 30 years this coming June as a juvenile and probate court judge. But as Lauderdale is a class 4 county, I'm a part-time judge. And so I'm also a lawyer and have a part-time law practice, which is primarily family court law. So I do handle adoptions. And so both from the aspect of having been involved with child permanency for 30 years and also as a practitioner having been involved in adoptions, I was very interested in this bill.
Right. Are there any questions for for Judge Rachel Jackson?
I did want to tell you what my position is, if you don't mind.
Oh.
Is that appropriate?
I thought you were finished.
Oh, no,
You
I'm
took that
sorry,
deep breath.
Chairman.
You go right ahead.
Hello, Representative Dog. Nice to see you as well. I came today because I wanted to tell you all that in the history of my practice, I've been very involved with the court improvement program at the AOC. And in the late 1990s, there began a national effort toward expediting child permanency so that children could move out of both foster care settings and also any other kind of temporary custodial or guardianship settings into a lifelong, hopefully, setting with a family, either a permanent guardianship or an adoptive family. And I've been a part of that since the 1990s, having represented the judiciary at several national conferences on permanency. As a practitioner, what I wanted to say about this bill and why I think it's a very positive effort is that as a practical matter, these are cases that have already been before a judge to obtain an order of custody or guardianship, or again, there are cases where there's been some sort of lawful placement that's been the subject of a court action. In many rural counties especially, when you're asking for a home study as a requirement for a placement in a private adoption, you're assuming, number one, it's sort of like the bill you just considered. Have you got a provider to do that? And the truthful answer is no, we don't have the providers to give home studies in every case. Where there are providers, they're stretched thin. And so it creates a huge delay in permanency for these children. And it comes at an enormous cost. The last one of these that I was able to facilitate for one of my clients in an adoption was in excess of $4,000. That is huge to a family that's simply trying to achieve permanency for the child who resides in their home and who they want to give a permanent and healthy future for. So I'm very supportive of this bill. I thank you for the opportunity, and I'm happy to take any questions if there are any. And again, I come at this from two different perspectives, but I cannot imagine a lack of support for this effort.
Thank you very much. Sorry, I interrupted you.
I'm so sorry as well.
That's all right. Are there any questions? Representative Alexander, you're going to ask.
Yes, I just want to make sure that we're not putting children into any kind of harm's way. And I know the bill states, and I like the fact that it states they've already resided in that home for 6 months. Is there any kind of welfare check to know how that child is doing in that home at all? Especially in rural areas, because I'm from a rural area and I like to know that.
So
Judge
when you
Jackson,
ask,
you're recognized.
I'm sorry. When you ask about a welfare check, I'm assuming you're asking whether there's some sort of state involvement to inspect the home and ensure that it's a safe place. These are for private adoptions. DCS does not facilitate home studies in private adoptions. So these are cases where DCS would not be involved, and certainly even where they're asked, they will not facilitate home studies. So this is an entirely different creature from the home study that I, as a judge, am used to ordering, because this is coming from a private agency. Sometimes it's a licensed child placement agency, but again, typically we have to go to Shelby County or Davidson County to even find a provider. We've got to wait because there are so few of them and pay enormous fees.
You're recognized.
You answered my question. Thank you very
Thank
much.
you.
Thank you, Chairman.
Are there any other questions? Seeing none, are we ready to go back into session?
Yes.
We are back in session. So without objection, we will be rolling House Bill 1692 1 week.
Thank you, Chairman.
And without objection, we're going to go out of order, and because some of the members have to leave for a few minutes. And I'm going to turn the gavel over to Chairman Doggett. Judge, Chairman, Senator. We'll just do them all.
Thank you. All right, item number 11, House Bill 2188 by the Chair Lady Littleton.
Motion.
You are recognized. There's Amendment Code 13741. You wish to proceed with that amendment?
Yes, Chairman, I do. It makes the bill.
All right. All right. All those in favor of adopting Amendment Code 13741 on the House Bill 2188, say aye.
Aye.
Those opposed, the ayes prevail. You adopt. We are on your bill as amended.
Thank you, Chairman Doggett. Judge Doggett. Requires the Department of Children's Services to collaborate with the Department of Disability and Aging to ensure the children in state custody or at risk of coming into state custody and who have intellectual or developmental disabilities receive appropriate services and supports. Authorizes the DDA to develop training for DCS related to identification and of supports of the child with a disability, and to provide consultation and oversight tools and monitoring of residential services for children with a disability. authorizes DCS to refer children suspected to have had intellectual or developmental disability to DDA for service recommendations, and requires the DCS to submit a report outlining its compliance with the legislation on January the 1st, 2027.
You've heard the description. Any questions for the sponsor? Seeing none. Any objection to the question? Seeing none. We're now voting to send House Bill 2188 as amended on the full judiciary. Has everyone voted? Anyone wish to change their vote? Madam Clerk, take the vote.
Mr. Chair, you have 7 ayes and 0 noes.
The ayes prevail. House Bill 2188 as amended moves on to full judiciary.
So now we are back to House, number 10, House Bill 315 by Chairman Belso.
Motion.
Properly motioned and second. You are recognized, Chairman Belso.
Thank you,
Can I
Madam
see
Chair.
an amendment?
Yes, the amendment drafting code is 013774.
Would you like to go ahead and get that on?
Yes.
Is there a motion for the amendment? Motion.
Sure.
Properly motion and second. All those in favor of putting 013774 onto 315, say aye.
Aye.
Those opposed, no. The ayes have it.
No.
If you want to be recognized, that's a no. Tell the clerk. Okay. So you are recognized, Chairman Bolso, on House Bill 315 as amended.
Thank you, Madam Chair. Members, this bill is to correct a mistake that we made 2 years ago in this body when we amended our marriage statute 36-3-104. At the time, Chairman Dale Carr ran an amendment that, as described, only intended to revise the marriage statute such that individuals who were 18 or older did not have to provide information regarding their parents when filling out a license for a marriage application. In fact, the bill that was unanimously adopted in the House removed the words male and female from the marriage statute, making the statute such that individuals of the same sex could also become married in Tennessee. The bill passed in the Senate completely on the consent agenda because it was not raised in the Senate either that this bill actually removed the words male and female from our marriage statute. And one reason why this is such a problem is that many of you recall that in 2006, the Tennessee Constitution was amended and Section 18 of Article 11 was added, which states specifically that in Tennessee, any law that purports to define marriage as anything other than a legal contract to be between one man and one woman is void and unenforceable. So all this bill does is to put back into our marriage statute the 3 words, quote, male and female, close quote, that were removed by mistake in 2024. And with that, Madam Chair, I'm happy to answer any questions.
Are there any questions for Chairman Bolso? Representative Harris, you're recognized.
Thank you, Madam Chair. And Madam Chair, are we able to go back and forth, or do we need to go one question at a time?
You can go back. Excuse me, we do have someone to speak. Would you rather do that now or after the questions?
I'm going to go back and forth.
Okay, y'all can go back and forth.
Awesome. Thank you, Chair. So I know you stated that it just makes that small change, but it does make quite a bit of changes. Do you agree with that?
No. What I agree that it does is it puts back into the statute words that were mistakenly removed in 2024.
Chair, so what do you mean when you say mistakenly?
I mean that when the members of the General Assembly voted on the bill that was being advanced by Chairman Carr, that it was never pointed out in any committee meeting or on the House floor that the words male and female were being removed from the statute, which is how it was passed unanimously in the House. It never would have been passed unanimously had we been advised that what the bill did was not simply change whether or not adults had to get address and name information of their parents, but that the bill actually removed the words male and female. That's why it was a mistake.
What year was that?
It's 2024.
Okay. And does requiring prolonged separation endanger victims of abuse?
Could you ask me that again, Representative?
Yes. Does requiring prolonged separation endanger victims of abuse?
I have no opinion on that.
Part of the legislation, it puts a gap in how long a person has between the time that they are able to get a divorce on this period. So I'm asking that question as far as the language in the legislation.
Yeah, I'm not familiar with what language you're referring to, Representative.
Okay, I'll come back to that one. In domestic abuse cases, does limiting divorce options burden victims disproportionately?
I have no opinion on that.
Okay, so there's no mention of divorce in this language.
The word divorce does not appear in the bill. That is correct.
At all.
You're on the bill before it was amended.
Okay, so if you can tell me, based off of the bill that we currently have right now, all the change that is going to happen on here is adding and changing female and male in the language.
Let me express that slightly differently, Representative. All the bill does is it adds the words, quote, male and female, close quote, to the existing statute.
And so then if we make that change, what will it ultimately be able to do?
If we make that change, it will enable the statute to comply with Article 11, Section 18 of the Tennessee Constitution.
Which then says what?
Which says that in Tennessee, any law that purports to define marriage as anything other than a legal contract between one man and one woman is contrary to the public policy of the state and is void and unenforceable.
Okay, so then why, if we make that change, why are we attempting this if we know that we're going to ultimately, it probably will get struck down based off of this, considering that the Supreme Court in November of 2025 declined to hear the challenge to overfill by former Kentucky County Clerk, Ms. Davis. So why would we do that if we know that they've already tried to challenge this before?
Well, two reasons, Representative. One, we have an obligation to make sure that the laws we pass comply with the Tennessee Constitution. And when the words male and female were removed from the statute in 2024, it violated the Tennessee Constitution. And then second, I do not believe it will be challenged because this language is not going to be enforced currently because of the U.S. Supreme Court's decision in Obergefell versus Hodges back in 2015.
Thank you. Chair, I do have a question for legal when we go back, if possible.
You want now?
Yep.
Okay. So we'll go out of session and for legal. Ms. Fogarty, you are recognized.
Thank you, Ms. Fogarty.
Oh.
So I thought you had to introduce yourself first. Does she have to say anything before I speak?
Go ahead.
Okay, great. So with this language currently, if we were to pass this, does this put us in any challenge at all with the Supreme Court at all? Is this like we're just making modifications, clean up language, or does this actually make any changes? And if so, what changes will this actually make to our laws, and where does it stand with our Constitution?
Michelle Fogarty, Office of Legal Services. As amended, if this bill were to pass, the first sentence of subsection A of TCA section 36-3-104 would read, a county clerk or deputy clerk shall not issue a marriage license until the applicants make an application in writing stating the names, ages, current addresses, and social security numbers of both of the proposed male and female contracting parties.
Thank you. And so then who would do the same for those of same gender?
There is no provision in the bill for that.
Okay, thank you.
Any more questions for legal? Seeing none, we're back without objection, back in session. Are there any other questions?
I'm going with that.
So we will go out of session again and call up Ms. Rachel Welty. If you would come forward and introduce yourself and tell us who you're with, please.
Yes. Good afternoon. My name is Rachel Welty. I'm a family law attorney in Nashville, Tennessee, who's been practicing for 19 years. I'm having to pivot a little bit today because I thought I was here speaking against the Covenant Marriage Act and prolonged separation for couples. I own a child advocacy-focused family law firm who focuses children in everything we do in regard to divorce, adoptions, guardian ad litem work. I had lots of opinions on that one. And I also work with a lot of LGBTQ couples and divorcing couples in helping their children get to a better place after divorce. I always say I don't advocate for divorce, but sometimes it is necessary. And so in looking at this as amended, practically, my concern is what courts and what are we going to be doing for children who are the product of same-sex marriages? They deserve to have advocacy. They deserve to have specificity regarding their families. And one thing I know about children during a divorce, it's a really terrible time for them. And the best thing we can do for them is get the families on the other side of it so that the children are not stuck in the middle of the parental conflict. And so without specificity in the statutes in regard to what we do with them, my fear would be we are putting children in harm's way, affecting negatively their mental health in regard to what's going to happen with some of these cases. I know from doing this work for a really, really long time that the people that are affected the most when divorce happens, if it's necessary, are the children. And so what I've done for 19 years is to try to shake things up in courts to say we need to do this differently. We need to do better by these children. We know that for adverse childhood experience and ACEs, which I'm sure you guys are familiar with, is one of them is divorce. One of them is conflict in a home. And so I do have some concern about male and female being put in here. So that is my pivot for this afternoon, if there's any questions for me.
And you beat the clock, so very good. Are there any questions for Ms. Rachel, Rachel Welty?
Yes, thank you.
Seeing none, thank you very much for being
Thank
here.
you so much.
So we're back in session. So are there any other questions for Representative Bosso? You're recognized.
Thank you, Chair. So I do have a question. I'm looking at the language just as it is right now. So it says a county clerk or deputy clerk shall not issue a marriage license until the applicants make an application in writing, states the name, ages, current address, and social security numbers of both the proposed male and female contracting parties. So kind of what I just asked from legal, where will those who may be male and female be able to do in this part?
If I understand the question properly, Representative, passage of this bill is not going to affect the ability of individuals of the same sex to marry in the state of Tennessee. The U.S. Supreme Court has ruled on that under the 14th Amendment in Obergefell. What this bill does is it corrects a mistake that was made 2 years ago, and it brings this statute back into compliance with Article 11, Section 18 of our state constitution.
Right, but you're saying that then so they will be able to apply just like anyone else would. It does not do anything different. So what does this do differently than what we currently have in language?
It will do nothing differently. Recall that Obergefell was decided in 2015. And from that point forward in Tennessee, as in all other states in the country, individuals of the same sex were allowed to marry. That continued even though our statute said male and female contracting parties. Male and female wasn't taken out until 9 years after Obergefell. in 2024. So what we're simply doing is correcting a mistake that was made 2 years ago to put the statute back the way it needs to be to comply with the Tennessee Constitution. But this will have no immediate practical effect on marriage in the state.
So I,
One more.
so I struggle to understand how that's possible when it says a county clerk or deputy clerk shall not issue a marriage license until all these things are met. So this is going to stop them from being able to issue a marriage license until these things are met. And if they are, if you and your boyfriend went and decide that you wanted to go get married, then you won't be able to do that. If somebody wanted to, because the language is very specific, right? Or am I wrong? What am I looking at differently?
Yeah, respectfully, Representative, I think you are incorrect. I think that even if this bill is enacted, the practice of marriage in Tennessee will not change.
So which one is wrong? Which this legislation or the Constitution, which one is like wrong? Because if we're still going to do it, even though it's not going to make any difference, then what's the point in doing it?
The point is, as I've mentioned several times, is to correct a mistake that the General Assembly made 2 years ago.
A unanimous mistake.
Yes, it was unanimous in the House of Representatives. It was unanimous on the consent calendar in the Senate, which would never have been the case if this change had been called to the attention of the General Assembly when it was presented in committee or on the House floor.
Okay. Are there any other questions for Representative Bosso? Seeing none, are we ready to vote? Clerk, would you please open the board? All those in favor of House Bill 315 as amended, moving out to judiciary, please vote yes. Those opposed, vote no. Madam Clerk, would you please take the vote?
Shame! How dare you!
Madam Chair, you have 5 ayes and 1 nay.
Your bill, House Bill 315 moves out to, as amended, moves out to judiciary. You're out of order.
God, the Bible literally says it. This should not happen. You want to get sued? Come on, you. You got evidence.
Without objection, we are adjourned.